everyone. My name is Giovanni Nogales, and I am a paralegal here at Laos Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Medicare Revocation, Avoiding Common Mistakes and Appealing the Revocation of Your Billing Privilege. Today's presenters are Ashley Morgan and Jennifer Papapanagiotou. Ashley Morgan is a partner in Laos Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with the wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board compliance, and exclusion and termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. As for Jennifer Papanagiotou's practice focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has an extensive experience in analyzing proposed and existing businesses arrangements for compliance with federal and state fraud and abuse laws and drafting a wide variety of legal agreements. Ms. Papapanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers, and in Medicare, Medicaid enrollment, including in initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we'll address them as many as possible at the end of the presentation. So without further ado, I present to you your speakers, Ashley Morgan and Jennifer Papapanagiotou.
Thank you so much, Gio, for that introduction, and thank you all for joining us this afternoon to talk about revocations. And Gio, we can go ahead and go into the next slide. Okay, so this is just a brief overview of what we're going to talk about today. And just a reminder for everybody on the line that today's presentation is just informational in nature and does not constitute legal advice. But today we're going to talk about the 19 revocation reasons. Then we're going to talk about the fastest path to losing your Medicare number and how to avoid them. And then what if the worst happens, if you do receive a revocation letter, and what that response looks like and that appeals process. Next slide. Okay, so we're going to briefly go over the 19 revocation reasons. We're going to show all of them on the slides, but we have a few that are in bold and red for you all. These are the most common, which also happen to be the types of cases that we, also work on the most and see the most as a revocation reason that's actually utilized by CMS. So I will note that the first reason that's listed, the not in compliance, we do see that revocation reason, but typically it's in conjunction with some of these other revocation reasons that we have in red on the screen. And we are going to go in more detail about all of these revocations, at least the ones in red, as we go through the presentation today. So the first reason we see providers get revoked is that they are not in compliance with Medicare requirements that are stated in the enrollment application or the regulations governing enrollment. So for example, if you failed to disclose information, if you failed to update your enrollment information, you could be revoked for failure to comply with the Medicare requirements. We also see revocations for providers who are actually excluded or debarred from a federal program. If you as an actual provider, or if any of your owners, managing employees, authorized or delegated officials, medical directors, supervising physicians, or other healthcare personnel are actually excluded, then you can be revoked for that reason. Felony convictions, if you have a felony conviction in the last 10 years, the CMS finds to be detrimental to the Medicare program or its beneficiaries, you can be revoked for that reason. If you have false or misleading information on an application, that is a common revocation reason that we see. And a note on this one that if you omit information, or if you simply, forget to provide information, or if it's a clerical error, if that information is missing from an application, CMS does constitute that as misstating info and as false or misleading information. So it's important that when you are completing enrollment applications or doing, a revalidation application or updating your current enrollment information, that all the information that you submit to CMS is in fact correct, to avoid revocation for that reason. Another common reason we see are on-site reviews or other reliable evidence that requirements are not met. This is typically a failed site visit, and typically this is included with reason 1 above the not in compliance with Medicare requirements. So a lot of times what we see here is that CMS will come out for a site visit, and either you have moved or you've put your correspondence address as your practice location and it doesn't happen to be the same place. And so CMS shows up, tries to conduct their site visit. You're not there. There's no indication that your practice is there. You're not closed, or even, if you are closed and not operating during your practice hours, that can be a problem as well. But we see providers get revoked for that reason. And then also CMS cites that you're not in compliance with Medicare requirements for failure to update your practice location on your Medicare enrollment application. And then you have to fight both of those denial reasons as you're going through the appeals process. The last two on the screen are hardship exceptions and misuse of billing number, knowingly letting another provider use your billing number. We don't see those used as often as the some of the other revocation reasons. Let's go on to the next screen. Okay, abuse of billing privileges. This is a big one, and we're actually seeing this used as a revocation reason more often now. Typically, this revocation reason in the past was just used really for what we call the 3 strikes rule. And it was used in connection where a provider was billing for dead beneficiaries. And believe it or not, in the Federal Register, there's actually language there that indicates that it is okay. CMS understands that, sometimes there are billing mistakes and a claim gets submitted and has the wrong date as an error. So the regulations do allow you to bill for a deceased beneficiary 2 times, but if you bill that 3rd time, just like in baseball, you're out and you get revoked. And that was typically what this revocation reason was used for. However, there is now, when the regulations were updated, there is a pattern or practice of billing errors as a reason as well for revocation. And now we are seeing CMS send revocation letters to providers who have been audited in the past and citing prior audits, prior error rates, and revoking providers. And we are going to talk about this in more detail because this is really important that everybody understands this. But we are seeing a lot of activity on this this revocation reason, so it's important that you are taking all audits seriously. And like I said, we'll provide some more information on this one as we get into more detail today. Failure to report changes. This is another option to revoke if you have, like I was talking about before, for site visits or for non-compliance. If you fail to report an adverse action or a change in location, this is another way they can revoke you for failure to report changes. Non-compliance with documentation requirements, capitalization issues. If you have your Medicaid billing privileges revoked, that's a common one that we see. So if Medicaid comes through and revokes your billing privileges, then Medicare will follow suit. And I've seen that happen actually in connection with providers who have had a bad history of Medicaid audits, and Medicaid comes in and does an audit, they get a bad error rate, Medicaid revokes the provider, and then Medicare gets wind of that and then also, revokes based on the Medicaid issue. And those are hard to fix because, Medicare will take the position that, unless you can fix your position with Medicaid, they're not going to let you back in. So you have to not only deal with Medicare, but you're dealing with Medicaid and fighting them on, the underlying revocation reason as well. We also see revocations for DEA certificate suspensions or revocations. and improper prescribing practices. For example, if CMS determines that a physician or another eligible professional has a pattern or practice of prescribing Part D drugs that is abusive or represents a threat to the health or safety of Medicare beneficiaries or otherwise fails to meet Medicare requirements. Next slide. And here are the additional revocation reasons. So a debt referred to the United States Treasury, that is a new one that came out when the regulations were revised, and now you can be revoked if you have an overpayment out there from a prior audit and it is unpaid and it gets referred to the Treasury, then CMS can come and revoke you for that reason. So it's important that you're challenging all, adverse actions against you for audits, for example, for a post-payment audit, you're challenging that through the appeals process. And if you do have an overpayment assessed against you, that you're taking action to repay that debt as necessary so that it does not get referred to Treasury and then, subsequently could cause you to get revoked. If you are revoked under another name, numerical identifier, or a business entity, if you have another group that's revoked under a different name and CMS goes and looks, they can revoke another practice. And similar to that, if there is an affiliation that poses an undue risk. So if CMS reviews and they see that there's common ownership or that there's a common managing employee that they determine poses an undue risk, and we will talk about what that means, but an example would be if you have another home health agency, for example, that has had a prior overpayment debt that was referred to Treasury that's sitting out there, and you just shut that practice down and opened up another one, CMS could review and determine that, you were either revoked under another name or that there is an affiliation that exists that poses an undue risk, and they could revoke, your currently active Medicare number based simply on the fact that you have some sort of affiliation to a company that owes a debt to Medicare. And billing from a non-compliant location, that's another big one that we see. And finally, abusive ordering, certifying, referring, or prescribing of Part A or Part B services, items, or drugs. Next slide. Okay, so we are going to kind of break down for you the fastest paths to losing your Medicare number or essentially, getting revoked. So we have organized these into buckets, into 4 buckets that we're going to review today. Because as I indicated before, some of the revocations are rarely used and some are much more common, and they really fall into these 4 basic areas. So these are enrollment problems, which include failure to report a change in location, failure to revalidate on time, failure to report an adverse legal action, operational problems, which can include failure to keep regular business hours, lacking proper signage, employing excluded persons, billing problems, which include repeated high error rate on claim audits, for example, UPIC audits, TPE audits, and then documentation, failing to keep required paperwork to support the payments for the services that you're billing Medicare for. So we're going to discuss each of these buckets and the revocation reasons that underlie them, concerns with those, and some things you can do to prevent a revocation. Let's go on to the next slide. Okay, so first we're going to talk about enrollment problems. Next slide. So one reason that we see related to enrollment is related to revocation reason number 5, that there is an on-site review or other reliable evidence that requirements are not met. Common things that we see related to this revocation reason is that there is a site review done, a site visit, and CMS shows up and they can't find your practice location. You're not there. This happens a lot if a provider has moved locations and has not yet updated their enrollment application with CMS to reflect that new location. And CMS will come out and do a site visit. And as I said previously, non-compliance is also often cited with this because CMS will say, okay, we did a site visit, you failed the site visit, so we're revoking you based on that, and then we're also revoking you because you failed to keep your enrollment information accurate with CMS. How to prevent this? Make sure you keep your enrollment records up to date. You should never use a PO box as your practice location. We have seen that in the past, unfortunately, that a provider has used a PO box or a FedEx Kinko's as their practice location. Do not do that. Please make sure if you're having somebody else prepare your enrollment application that you actually review it and make sure it's correct. There are separate sections there for a correspondence address and for an actual physical practice location address. You need to make sure those are correct. You would not believe how often we see this happen, where a provider, says, well, all of my information was correct. I don't, they didn't even call me when they did the site visit. And a lot of times they won't. They will just do a drive-by. And if you are not there, then, you can get revoked. So it's very important that you review that enrollment record and make sure it's correct, and make sure you understand that just because your information on, for example, the MPPES might be correct, that does not mean that your PAYCOS record is correct or that your enrollment application with CMS is correct. So your enrollment application, that PAYCOS login, that is where your information needs to be correct. CMS will pull your practice location from that record, not from any other area. And make sure you keep copies of everything you submit. We highly recommend that you use paper applications instead of PAYCOS. It's just easier to keep track of and to track. You can keep a physical copy. You know exactly what it said when you wrote down on the application what your address was, and then submit those via trackable mail so you can confirm that it was actually delivered. If you are going to use PAYCOS, please make sure you actually print the entire submission before you actually press submit on that application so that you have a record of what it said. If we can go to the next slide, because I'm going to continue with a few more points. So again, make sure you're filling out your applications truthfully and completely. The authorized rep attests that the information submitted is accurate and the provider or supplier is aware of and abides by all applicable statutes, regulations, and program instructions. So you're signing that certification, the authorized rep is signing that certification. They will hold you to that you said that the information was correct. It doesn't matter if it was a clerical error. They will say, this is what you certified, this is what you agreed to, and we're holding you to that. Make sure you send in all of your required attachments. And again, that you check the application and that you submit it via trackable mail. The only way we really see that this can get fixed is if you can show that you did in fact submit an application that had the correct information on it. So it's really important that you do your due diligence, practice defensive driving when you're doing your credentialing applications and doing a change of information, that that information is correct and you're able to prove it in the event that something does happen. So just make sure you keep copies of everything, and please don't ever just allow somebody to submit something on your behalf. Don't just sign a signature page and never review the application. Make sure you are reviewing everything individually yourself and making sure that there is a copy so that you can prove what you submitted should you need to in the future. And in the event that there's a question, I would suggest over-disclosing information as opposed to under-reporting. If you have a question in your mind as to whether something needs to be on the application, it's always better to over-disclose than under-disclose. Next slide. Okay. Again, site visits. This is a very important one. We see this a lot for home health agencies and hospices. These can be random or as part of a pending application. Again, these are address and operational status checks only. So you will likely not know that CMS is coming to do a site visit. They will just do a drive-by. They will look to see whether it looks like your agency is operational. They may look to see whether you have the correct posted hours and whether you're actually open for business. Is there somebody inside? But you may not know they are coming, and they may not come in and talk to you. They may just do a drive-by. Providers and suppliers in the moderate and high screening categories are most likely to have site visits, and hospices and revalidating home health agencies are in the moderate screening category. And then in the high screening category, we have new home health agencies and any provider or supplier that has been revoked and is applying for reactivation after a re-enrollment bar is run out. So if you fall into either of those buckets, which I think most people on this call would, it's important to know that you are likely going to have a site visit if you have not. And if you don't pass that site visit, then you either start out again at the start of the application process. If you are just submitting an enrollment application, your enrollment application will likely get denied, or you can be revoked if you're currently enrolled. So just very, very important, again, to make sure your practice location is actually correct in PACOS or on the enrollment application that you submitted. And something new that is coming are fingerprint-based background checks. This is new for home health agencies and high-risk providers, and it's only going to happen upon request. But if you do get a request, take it seriously. The contractor that is going to be doing these fingerprint-based background checks is called Accurate Biometrics. I know sometimes, people get a lot of mail and they don't know whether it's legitimate or not. This is a legitimate request that will be coming from CMS on behalf of Accurate Biometrics. So it's coming. It does not appear to be widely implemented yet. And it's only for home health agencies and for DME providers right now. But just be aware that it is a possibility. So, again, if you do get contacted by Accurate Biometrics, take that seriously. It is not a spam or a phishing attempt or anything like that. It's legitimate. Next slide. So enrollment and reporting obligations. This plays off of what I was just talking about, that you do have an obligation to keep your enrollment application with CMS up to date. We have made a chart for you here so you can know when you need to report changes by, because there are timelines and they differ depending on what kind of change it is. So if you have a change of ownership, for example, or a change of control, or a change of your authorized or delegated representative, you have 30 days to report that change in information. For other changes in information, like a change of practice location, for example, you have 90 days to submit that information to CMS. For a final adverse legal action, it depends. It's 30 days if it's for a license revocation or suspension, or 90 days for other adverse legal actions. And, you would need to do an analysis to determine, what needs to be reported, obviously. And then any other changes to any section of the CMS 855 has to be reported within 90 days. And we do see, again, revocations for failure to report changes. So it's important that you know these timelines and that you do submit timely changes in information to CMS, so that you don't see a subsequent, revocation action for failing to notify them timely of a change of the information that's located on your CMS 855 or on your enrollment application. I also want to note that state licensing laws also mandate reporting deadlines, so you need to be aware of those. For example, any change of location must be reported to the Texas DADS 30 days in advance. Changes in ownership, which is a change in 50% ownership, requires an advanced filing application, ideally delivered 30 days in advance of closing, but it can be later if you pay a late fee, so long as it's before you close. So it's just important to know that not just Medicare that you have to report changes to, there's likely also changes that need to be reported to the state. And if you do have any private payer contracts or managed care contracts, you may also have reporting obligations to them as well. So it's just important to know what all those requirements are so you avoid any adverse action from your payers for failing to notify them timely about changes. Next slide. Okay, revalidation. The requirements, we've got the regulation listed on the screen for you if you want to see what the specific requirements are for revalidation. You do have to revalidate every 5 years based upon request. If you miss a deadline, that can result in a payment hold and a subsequent deactivation, which means you can't provide services. There is a website, and we have it on the screen for you. You can check that website for your agency to see when you are due for revalidation and the instructions for revalidation, and that website is updated every 2 months. If your revalidation is due within 6 months, your organization should appear there. We recommend that once you see yourself on the due date list, that you go ahead, get that revalidation application completed and submit it. I wouldn't recommend, waiting until the very last minute to get that application ready. If you have not completed revalidation yet, you will get an email or a letter 2 to 3 months before your due date. Make sure your correspondence addresses and email address are up to date on your enrollment record. So again, log into Paycos and look at what your correspondence address says. There are several different areas on that Paycos application or on the A55. So make sure the information that is listed there in your correspondence address specifically is up to date. It may be old, and you may have another email address somewhere else, and you may get emails from CMS to another email address, but they will send the correspondence to the email address, the phone number in your correspondence address that's listed in Paycos, or that was listed in your most recent A55 that you submitted. And it's important that you double check that, because I know it's been a while, because they paused revalidation for during COVID. So now a lot of people are going through revalidation, but you may have not have updated your information in a while because of that pause in revalidation. So make sure that information is correct so that you do get notification prior to your due date. And again, another way to make sure you're not missing that deadline is to check the website as well. You are going to have to pay a fee to revalidate. Home health and hospices pay a $688 fee to revalidate. You're going to get prompted by Paycos to pay before you actually submit the application, if you do submit it through Paycos. If you miss your deadline, it's okay. Don't, you still want to submit it as soon as possible. You will be reactivated, but there's likely going to be a gap in your effective dates. You will likely be reactivated the date that you submit that application. But know that, you will likely have a gap in any time period between when your revalidation application deadline was and the date that you submit that new application. And we have worked with providers to fight those gaps. It's a difficult argument to make. We have been successful previously, but obviously the best choice is to know when your revalidation application is due and to submit it timely so that you're not dealing with having to have a gap in your enrollment information, submitting, a late application, and then trying to get payment for that deactivation period. I think we can go ahead and go on to the next slide. Okay. A few notes and things to avoid. I know I've said this a couple times already. Please use Paycos at your own risk. Once a Paycos application is in process, that original data submitted can change. Also, Paycos doesn't give users access to previous applications, which is why we recommend printing out a copy of your application before you actually press submit, so you know what it says when you submitted it. If you're revoked and you can't access your previous applications to show what you actually submitted, it makes it really hard for us to fight with CMS about what your application said, because we don't have any way to actually prove it except through an affidavit and your statements about what you actually said. So the best defense, obviously, and to practice your defensive driving again, would be to print that application before you submit it, or again use the paper A55. Update your enrollment. Every time you have a new provider, owner, or managing person, make sure you update that enrollment record. Send your application separately. There is Paycos 2.0 that's coming. It's going to revamp the entire process. And it will automate this and allow a consolidated application to update multiple records of the same supplier or provider type. But right now that's not available, so we recommend sending paper applications to change that information and to do separate applications for every different provider, owner, or managing employee. The reporting and revalidation deadlines for apply for the actual certification pages too. So if you're submitting your revalidation application through PAYCOS, you do still need to, send the paper PAYCOS signature pages to CMS, and those also need to be submitted before your revalidation deadline. Sending the paper PAYCOS signature pages is going to be phased out with the new version of PAYCOS, but obviously that's still not here yet. So in the meantime, you do need to make sure that printed signature pages get submitted before your actual revalidation deadline. You must be able to prove actual delivery before your deadline passes. So it's not just I mailed it, it's I actually delivered it, CMS received it. That's what CMS considers. They consider it to be submitted as being delivered. So use trackable mail like FedEx, UPS, or some sort of trackable USPS mail, and print that proof of delivery and keep it with your application. I hope that you don't ever need it, but it's very good to have that should you need it in the future, so that you can prove that this is what my application said and this is when it was delivered. That can help resolve problems much more quickly in the event that there is any question about what was submitted and when it was submitted to CMS. Again, keep copies of your application, including the PAYCOS applications, and all of the attachments that you submit with that application. Keep all of those as well, any licensing information, etc. Keep that all together in a package. And if you miss a deadline, send the application anyway. You just get it in as quickly as you can. Again, there may be a gap in your enrollment. For example, if there was a revalidation application, but go ahead and get it on file because most likely you'll be reactivated back to the date that they did actually at least get the application from you. Okay, and I think Jennifer is going to talk about operational problems.
Yes, thank you, Ashley. We're going to turn to our second bucket of ways to lose your Medicare number and talk a little bit about operational problems. These do kind of link back to the first bucket, and you'll start to see that many of these are kind of interrelated. So let's go to the next slide. So again, when we talk about operational issues, there are a couple of common revocation reasons we see. The first is reason 5, which you saw Ashley talk about under that first bucket, which is just keeping your enrollment information up to date. I'm going to talk a little bit more about what those site inspectors are looking for when they go out and review your compliance with sort of the practical operational issues. So there are two common things that go off the rails. One, you have poor or no signage for your practice location. It's hard for them to find. And I've actually had clients revoked where, for example, they're in a multi-story building and their name didn't appear on a directory, or it appeared on the directory, but it was wrong, which I've actually had a case like that. And the site inspector didn't bother to actually go to the floor and the suite where the provider was supposed to be located. It just looked at the directory, went to the wrong place, didn't find the provider. And, site inspectors are not perfect people, just like we all make mistakes, but things can happen. So it's really important, especially if you're in a multi-tenant facility, that directory in the front of the building is accurate and has the name of your agency on it and has the right number, suite number. And then your actual physical location needs to have a sign that's visible from the outside. And it needs to have your name and the required information you are to have posted at all times, which generally is your hours of operation and your emergency contact phone number. The other way people fail for this particular reason is they don't keep regular business hours. So you may still be at your address of record, but for whatever reason, the lights are out and nobody's home when that site inspector comes by. They will only come during your reported hours of operation, and they'll make several attempts to come to your location before they submit that report that you failed a site visit. So if you say you're open from 8 a.m. to 5 p.m., you need to be there from 8 a.m. to 5 p.m. If they come to the right place and you're not open for business during regular hours, it's the same as if you've moved and you're not operational. So they're going to give you more than one shot. Usually it's a minimum of 2. Sometimes they'll even come a 3rd time. But this is, I don't see as many of these as I used to, but this used to be pretty common. The second reason operationally that we see where people can lose billing privileges is for employing excluded or debarred people. And this is purely your management of your employees and your verification of their credentials isn't something you only do at the beginning when you hire them. It has to be an ongoing validation and verification process. So if a provider, like a home health agency or a hospice, or any of that agency's owners, managing employees, authorized or delegated officials, medical directors, supervising physician, or other healthcare personnel is excluded or debarred from Medicare, Medicaid, or any other federal health benefit program, or if any of those people or entities are debarred, suspended, or otherwise excluded from participating in any other federal procurement or non-procurement program or activity, then your agency can lose its billing privileges. I've seen a couple of these cases over the years. It's usually an owner or managing employee that had some history with one of the programs and somehow ended up excluded, usually by OIG, could be by a state integrity program like HHSC OIG, like we have here in Texas. It could be an exclusion from another state, in a different state than where you're physically located. In these situations, these are fixable. The excluded or debarred, you can avoid them on the front end. And let's go to the next slide. You can avoid them on the front end by sort of institutionalizing and creating the right policies and procedures and then following them. But let's talk a little bit about how to prevent I got a site visit and they couldn't for whatever reason verify I was open for business, and then we'll talk a second about how do we handle that excluded and debarred person standard. So let's go to the next slide, please. So for reason 5 revocation, that's the lights are on but nobody was home, or you didn't have the proper signage up. State licensing and federal Medicare regs require home health and hospice to have signage and to post their hours of operation and emergency contact numbers. That's the minimum. It needs to be visible from the outside of your location. It's absolutely important that you treat your office like a retail business. You have to be open to receive patients and surveyors during your regular posted hours. You wouldn't close down the Gap so everybody could go to lunch. You wouldn't close down the hospital because everybody decided to go, run an errand to the post office. So if you are lightly staffed and you don't normally have more than one person at the office at the same time, and someone has to leave for some reason and your office will be shut down for some period of time during your regular posted hours, you've got to post a sign with contact number and the time you will return. Surveyors will be much more tolerant if they know that you're cognizant of the fact that, okay, I'm usually here from 8 to 5. I had to go out and run an errand, so I put a sign up and said, back in 30 minutes, and put a time and a date on it, and in an emergency, please contact this phone number. They'll then make a second visit during at a different time of day, generally speaking, to verify that you were actually operational. But it's incumbent on agency owners to have contingency plans if your normal staff, your normal receptionist, or whoever's going to sit in the front and make sure the lights are on and receive visitors, if that person can't be there, you've got to have a backup plan. There's just no way around it. So plan for an emergency and have those contingencies in place. I will also stress that someone has to actually answer the emergency contact number that is posted. And if they don't answer when someone calls, that someone's regularly checking messages and returning those phone calls. We have seen situations where site inspectors will call and leave multiple messages and never receive a return phone call. I've also seen site inspectors contact building managers to verify who is the tenant in that space and how to get in touch with them. Building managers don't really want to deal with those kinds of questions, to be honest with you. So it's just easier if you, fulfill your obligation to always monitor that emergency contact number and make sure phone calls are being returned. So let's go to the next slide. For excluded and debarred people, what we call reason 2 revocations, it's just important for you to constantly be monitoring and doing your validation and verification of licensure and exclusion screening for your employees on a regular basis. We recommend you do it monthly. And I know that sounds like a lot, but I will tell you that there are state regulations in Texas that recommend monthly exclusion screening. And the feds have not come down and said you have to do it on any kind of specific basis, but best practice is for sure to be doing exclusion checks on a monthly basis. The way you fix these, if a revocation were to happen, is you simply terminate or divest the excluded person immediately. It's better if you never have to go down the road of having received that revocation notice and then having to take action, because you have a very short window at that point. If you're doing your screening of your owners, managing employees, and all your staff, everybody, on a regular basis, that monthly basis, you should be able to identify these issues proactively and take action to remove someone who has this issue before you ever have to deal with a revocation. Removing a person who's been excluded is fairly routine if you do it proactively, and you do have to do it through the enrollment application to make sure that if they're on your enrollment record, they're removed. But this applies to your nursing staff, your therapy staff, your social worker, anybody who's on your staff. You should be screening everybody who participates in the delivery of healthcare services on a monthly basis and keeping records of that screening. If you use staffing agencies, outside sources for staff, your contracts with them should be very explicit about who is going to screen them. If you're going to make that an obligation of the staffing agency, then I highly recommend that's written into your contract with them, and that you've got, some kind of indemnification language in that contract that if they fail to do it, they're going to be financially responsible for any damage that you suffer as a result of them potentially, sending you an excluded person to see one of your patients. I also, if you're going to rely on a staffing agency to do its own screening, you need to review that they're actually doing it and ask for proof from them that they're doing their exclusion screening. You can also do the screening yourself, especially if you're using the same staff over and over again, and keep those records. I don't care who does it, but somebody has to do it, and you need to be able to prove if you're ever asked to show that screening is done. If you're going through an acquisition, then my recommendation to buyers is always that you screen everybody you're going to take onto your staff as part of that acquisition before you close that transaction. And if you identify an excluded, debarred, or suspended person, there can be an overpayment associated with that person having been part of your organization for some period of time. If that is the case and you identify someone who's excluded or debarred that you need to take action on, our advice is that you contact your legal counsel to talk about what to do about the potential financial impact. It can result in overpayments that need to be addressed, and there's a self-disclosure protocol with the Office of Inspector General that we've taken people through this process before. Let's go to the next slide. All right, Ashley mentioned early on that the third big bucket of revocations we see are those related to billing problems, where you have high error rates on claim audits, and this can be any kind of claim audit. It can be PPE, it could be a UPIC audit. Let's go to the next slide. Several years ago, end of 2019, beginning of 2020, right before COVID hit, there was a big set of changes that were implemented to the revocation regulations. And while there had been an abuse of billing privileges revocation reason on the books for a long time, they greatly expanded it when they did these revisions and created a whole new category for what they call pattern or practice of billing errors. And it isn't what I call a bright line standard. This is what Ashley and I like to call the discretionary reasons. They're a bucket of what we call discretionary reasons, where CMS can use its discretion to decide if there is a pattern or practice of billing errors and decide whether it wants to take action if it believes that that pattern or practice presents a risk to the program. These are extraordinarily difficult revocations to fight. because they are discretionary decisions. And in the appeal process for revocation, the administrative law judges that hear these cases generally defer to CMS and its discretion. So it is absolutely critical that if you have an audit where you're seeing high error rates, that you're taking action early to fight those and to correct whatever issues may be there. We've seen a big uptick in these kinds of revocations. For a variety in a variety of different contexts. We're also seeing some interesting language appearing in letters from the contractors that do these audits. And we're going to show you some of those examples. But just to quickly run through the factors they're going to consider before imposing a revocation for a pattern or practice of billing errors include the denial rate, the denial reasons, the provider's history of final adverse actions and the nature of those actions, the length of time over which the pattern has continued. And I don't want you to think that it takes 5 years of bad audits, because that is not the case. It could be 3 audits conducted over 3 years. It could be 3 audits conducted over 18 months. They're very fact specific, and CMS can pretty much create the factual support for their discretionary decision on whatever basis they want. Like I said, it's a difficult revocation reason to fight. They're going to look at how long the provider's been in the Medicare program and what their compliance history has been while they've been in the program. And then, quote, any other information that CMS deems relevant, which is the big catch-all that basically lets them, kind of throw in any other facts they think would support their position. This particular revocation reason is highly driven by data mining and audit activity by the MACs and UPICs. We've seen several examples already in the last probably 2 years. We had a provider in another state that had 3 fairly small audits over about a 2.5-year period, 100% error rate, and they didn't review large samples of claims. They weren't extrapolated reviews. These were just, they reviewed 30 claims. They decided there was a 100% error rate. They did another review, which the review period started right after the first review was released. They had another 100% error rate on 30 claims. And anybody who's been through an audit understands that that error rate is maybe not a true reflection of what the issues were with your particular claims, because claims can be denied for substantive reasons like medical necessity, but they can also be denied for technical reasons. A signature was missing, a date was missing. 100% error rate in healthcare world, in audit world, can mean a lot of things. It can be fairly benign and things that are easily fixed, or it can be very serious. So the denial rate itself is not a great indicator of exactly what was going on in an audit. But suffice to say, the provider had a third audit, quick on the heels of the second one, had another 100% error rate. But I will tell you, because of the type of provider it was, the overpayment in each of these 3 audits, even though the error rates were high, was under $4,000 for each review. And they said, it's $4,000. Why would I pay somebody to fight a $4,000 overpayment? We're just going to pay it back. And 6 months later, they were revoked. And well, actually, they were revoked and then suspended, which was a very odd situation. And there was really nothing we could do to fight it at that point. They hadn't appealed any of the audits. We couldn't take them through the administrative appeal process to fight the audits, and all of the appeal rights had lapsed. So it really created an untenable situation for them. And long story, that business no longer exists. So pattern or practice of billing errors. We've also seen hospices suspended for credible allegations of fraud and then revoked. And that is, again, another way CMS can find a pattern or practice of billing errors. And, like I said, repeated UPIC audits, usually 3, with higher error rates, are kind of the running theme we see in these cases. Let's go to the next slide. We wanted to show you some of the language that we're actually seeing in letters and communications from contractors. The first quote we have here is from a TPE result letter. If after 3 rounds of TPE, there are continued high denials, Palmetto will refer this provider to the Centers for Medicare and Medicaid Services for additional action, which could include 100% prepaid review, extrapolation, referral to recovery auditor, et cetera. The et cetera is, you know, what we worry about. And the second quote is from the UPIC audit result letter. And this is starting to appear in every single UPIC letter. We remind you the regulation at 424-535 authorizes us to revoke Medicare billing privileges under certain conditions. And in particular, we note that per this cited reg, CMS has the authority to revoke a currently enrolled provider or supplier if CMS determines that there's a pattern or practice of submitting claims that fail to meet Medicare requirements. So they're putting everybody on notice. You know, the revocation reason exists, and now it's actually filtered down into the communications that providers are receiving from the integrity contractors. Let's go to the next page.
And I just want to add one quick thing, Jennifer.
Sure.
For the UPIC review specifically, I'm actually also starting to see, in addition to that language that we have on the last slide, that if a provider's receiving, for example, their second UPIC audit results from a UPIC, I've actually seen the UPIC say that, you know, they're receiving, this is the second time they've received education on this issue, and reminding them again that they do have that authority to revoke. So we're also seeing it come in the form of education, them saying you were educated on this issue previously and haven't made changes. So they're definitely, you know, exercising their muscle with this revocation reason.
I would say this: CMS and the contractors are getting much better at documenting and putting in writing the things they need to support a revocation. And that's really what these warnings are intended to do, is to beef up the proof CMS needs to take these actions. So we've warned you, and now we've warned you a second time, you're on notice. You can't come back and say, we didn't realize this was ever going to happen. So let's go to the next slide, please. So how do we prevent a revocation for this? Well, if you have an internal compliance program and you're doing the kind of internal claim review you should be doing on a regular basis, or if your billing people are seeing denials or other errors, you need to fix what you can fix proactively. You know, if you see some common error happening internally as you're doing your own internal reviews, absolutely 100% fix it. Fix it if it's fixable. You need to have a compliance program, and it needs to include regular claim auditing. You need to be having fresh eyes look at documentation. It can be helpful if you don't have to do this, you know, monthly or quarterly, but it can be helpful to have an outside consultant, or, you know, our law firm does this for clients as well, but have a third party who doesn't look at your documentation all the time, give you a fresh look at it, and give you feedback on issues that they think may exist. You know, one of the things Ashley and I have seen, and we saw a spate of denials over, were in hospice disclosures and consents. And Ashley, you can speak to this a little bit, but we've seen this pop up in TPE recently when they changed the required language in hospice notifications. A lot of providers didn't update their documentation fast enough, and we saw a bunch of TPE denials just based on the consent forms that you hadn't properly informed the patients of various things. And you know, those are fixable unless you're 2 years into it and then you're sort of scratching your head about what to do about it. But you know, the reality is, if you have a regular routine internal compliance review going on, and perhaps engage a consultant, you know, maybe annually, to take a look at your documentation in a small set and give you feedback, you're going to be a long way towards preventing this from ever happening. You have to be educating your staff. It's not enough for your billers to see there's a problem and tell management. Management has to communicate it down the chain and educate your staff on what they need to be doing to improve documentation. And it's really important that you're looking at the entire claim cycle, from the record to the claim to the ERA, to make sure something isn't off. I've had some cases develop where we thought we were billing this, but apparently there was some error in the electronic process and we were getting paid. But for example, this was a physician practice, which isn't terribly relevant to you guys, but what was happening was their electronic medical record and their billing system were actually putting the wrong MPI number in the performing provider field on the electronic claim. You know, it was right on the input side, it was being changed in the creation of the electronic claim. And when the EOB came back, it was coming back with a different MPI number on it. And this provider was audited over it. And it was a big financial hit for the practice because, they weren't intentionally doing it, but they were still responsible for the overpayment. Appeal denials. If they're appealable in any way, shape, or form, appeal them, because even low dollar overpayments can become revocations if they happen repeatedly. It can be expensive. We understand that. We work with folks all the time to try to help mitigate and manage the costs associated with this kind of thing, but you have to take them seriously, even if the overpayment is small. Let's go to the next slide. So the last revocation reason are documentation problems. Let's go to the next slide. All providers are required to keep written and electronic documentation, including the MPI of the physician or, when permitted, other eligible professional who ordered, certified, referred, or prescribed a service. This is your physician certification, your plans of care, et cetera, physician orders relating to written orders, certifications, referrals, prescriptions, and requests for payment. So it's common. We know how hard it is to get physicians to sign things. But we also know that this is a pretty heavily audited area. And if you can't provide, for example, copies of signed orders from physicians, you can be revoked. So we don't see this quite as commonly as we do other revocation reasons, but it is something we've seen in the past. You must have a compliance program and do that regular claim auditing to make sure you get all the right pieces of paper and that they have the right required signatures on them and that the dates are appropriate. Saying it's hard to get signatures is never a defense. If you don't have a required signature on a document that has to be there before you begin service or before you file a claim, you can't file the claim, period. And that's the reality of the world we live in if you're going to serve Medicare beneficiaries. Don't clone notes. Every visit is unique in some way. That's less relevant in home health and hospice. I mean, obviously, nurses should be documenting their visits as unique visits. We don't want every single visit to look exactly the same because patients are never the same from visit to visit to visit. There may be subtle things that change and your notes need to reflect those subtle changes. You have to give feedback to staff. They won't improve without feedback and education. And I think it's a really great practice to go through notes with folks and show, this is what we're seeing. This is how we think we could improve and kind of make it a working exercise. Let's go to the next slide. So what if the absolute worst thing happens and you receive a revocation letter? Well, here's all the bad stuff. Look at the effective date of the revocation because it can be before the date of the revocation letter. Felony convictions will always be backdated to the date of conviction. Site visits will be the date of the last failed attempted site visit. Exclusion revocations will be the date or the person or entity was excluded. Most of the revocation reasons, it'll be 30 days after the date of the revocation letter. You will not get paid by Medicare after the revocation effective date, even if you file an appeal. There are no stays of revocation actions. So once that revocation goes into effect, even if you choose to appeal it, you will not get paid while that appeal is pending. You often have reporting obligations to other payers and authorities. Once you do report, Medicaid will likely revoke or terminate you. Private payer contracts often require you to report things like revocations. And if you're accredited, this is also a reportable action to your accrediting body. Let's go to the next slide. So that's the really, really bad stuff. So what can you do? What can you do to fight a revocation? Immediately contact healthcare counsel or find a health lawyer to help you. Discuss the appeal process and alternative business arrangements or workarounds that may help keep you in business. This is not the time to do it yourself. The first level of appeal is called reconsideration. We'll run through that in a second. It is what we call a evidentiary bar. You have to submit certain pieces of evidence with that very first appeal or you can never submit it. So it's really important that you have good counsel to help you prepare your first appeal. You have 60 days from the receipt of the revocation letter to file a reconsideration request. And in some cases, depending on your revocation reason, you may have 30 days to file a corrective action plan, although there are very limited scenarios where corrective action plans are now permitted. Your attorney will need as much time as possible to gather evidence and prepare your reconsideration request or your CAP, and they do not give extensions for these. You have to meet the deadline. If a revocation involves an excluded, suspended, or debarred person or entities, and you have to immediately remove that person, you have 30 days after receiving notice of the revocation to remove that person and file an appeal. And if you can meet that deadline, then they will remove the revocation. So this is, you know, some of these are super time sensitive. You should discuss alternative billing arrangements for Medicare with your attorney. Consider reducing your census of Medicare patients and transferring patients to other providers, and review your private pay contracts and determine if there's a potential impact on those. You need to think about how you're going to handle staff. How long can you afford to pay people? Who are your most critical key staff that you need to keep while you move patients around so that you can keep operations going while perhaps you file an appeal and fight it. And you really have to be realistic about your finances and how long you can stay in business while you fight a revocation. And those are all really, really fact-specific decisions, depending on what the revocation reason is and the underlying facts. I can't give anybody, this is how you should do it. Every revocation reason and set of facts is unique. And it's going to be really, important that not only that you are find a health lawyer to help you, but preferably someone who's been through this before and can help you understand sort of the bigger picture of how a revocation affects every aspect of your business. So let's go to the next slide. I said we'd run you through the appeal process. So in those situations where corrective action plans are permitted, it's only for what we call reason one revocations, and that's non-compliance with Medicare requirements. We don't see many of those in home health and hospice anymore. We do see them in DME cases. For some reason, it's still pretty common. But reason one, or cases that are solely reason one cases, that non-compliance are less and less common. But if that is one of the revocation reasons, you have 30 days to file a corrective action plan from the date you get the revocation letter. It can't fix a failure to report, but it often can be used to address mistakes by contractors, like failing to acknowledge an update that you mailed to them if you can prove that you delivered it and it had the information they said was missing on it. It can sometimes address survey issues, and you usually get a response on a corrective action plan within 30 to 60 days of when you file it. You will stay revoked the whole time, though. Reconsiderations are available for all revocation reasons. They have to be filed within 60 days of receiving the revocation letter, or you lose your appeal rights entirely, even if you file the CAP. Oftentimes, if we have cases where a CAP is an option, we prepare and have to file both, because you're never going to get a response on the CAP before the reconsideration is due. So you have to file the reconsideration to keep your appeal rights alive. As I said earlier, reconsideration is what we call an evidentiary milestone. All documentary evidence you ever want considered at any level of appeal must be submitted. So if you've got pieces of paper or electronic communications that you want a judge or the reviewer to see, to use to support your case, they have to be submitted with your first reconsideration request. You will not get them in later unless you have good cause, and good cause generally needs to mean it wasn't available at the time you filed the reconsideration request. We've actually seen, we've actually argued good cause in some second level appeals where certain pieces of paper simply they weren't available to the provider when they file a reconsideration request. And we have seen, situations where we've been able to do that. But, the biggest mistake I see people make is they try to do the first level reconsideration by themselves. They don't really understand the process. They call the contractor and they say, I just got this letter, I don't know what to do. And the person on the phone, who's just a random person who works in customer service, says, well, you just send us a letter and explain what happened and just do what it says in the revocation letter and send us your explanation. It's the biggest mistake people ever make is they listen to that person at the contractor on the phone and they don't call their attorney. Those people at Palmetto are not here to help you. And they are not knowledgeable about the appeal process, and you cannot rely on the advice they give you. They are simply, and saying in an appeal that I relied on the advice given to me by the contractor is never going to be a justification for why you didn't submit something that should be considered. That's just never going to happen. So it's really, really important you get good counsel when you file reconsideration, so that every piece of paper that might ever be relevant gets submitted at that level. Reconsiderations are reviewed either by Palmetto itself or by CMS, depending on what kind of provider you are and what the revocation reason is. More and more, they've taken all of the appeals away from the contractors for the most part. Not every time, but most often, they are being done by a central group at CMS in the Provider Enrollment and Oversight Group. There's an appeals division. Ashley and I know them well. We communicate with them regularly. And for the most part, they're handling most reconsideration requests now. You usually get an answer within 90 days of filing your reconsideration request. I will say they generally take the full 90 days. So if, for example, if you took 60 days to file your reconsideration request, they're going to take another 90 days to make a decision, and we can all do the math on that. You're 150 days in at that point with no money. So again, it's important that you have counsel who can help you kind of navigate that timeline and understand its impact. Reconsideration, you need to include all your factual and legal arguments and address all revocation reasons. It's another mistake I see people see is they address part of the revocation reasons but don't fully address others. And to win a reconsideration, you have to show CMS was wrong on every single point, not just one. So it's kind of an art form, and it's really more akin to administrative litigation than it is anything else. Let's go to the next slide. The third level of appeal, or the second level of appeal, I should say, there's CAP, which is optional. There's reconsideration, which is mandatory. If you lose at reconsideration and they affirm the revocation, then your next step is to go to the Departmental Appeals Board Civil Remedies Division. These are professional administrative law judges. All they hear are enrollment-related appeals, survey and certification appeals, and exclusion and debarment cases. You file a request for hearing within 60 days of receiving the reconsideration decision. And this is formal administrative litigation. There's procedure and written rules of procedure, and the administrative law judges handle these cases like any other administrative litigation. The good news, once you get to this level of appeal, is you file your request for appeal. The judge then notifies the local regional office of the Department of Health and Human Services, which for up in Texas is in Dallas. And the Dallas HHS Office of General Counsel actually appoints one of their attorneys to represent CMS in the case. And once they file their notice of appearance, we, if we're representing a provider, can then talk to that attorney. So they're the attorney for CMS, we're the attorney for the provider, and we can have discussions, conversations about the case. And this is where, you know, Ashley and I earn our money, is oftentimes, depending on the facts of the case, you know, we will go to this attorney that's representing CMS at this level of appeal and try to negotiate a resolution of the case that's more favorable than whatever we have in front of us at the time. So, you know, that's getting harder and harder to do, to be honest. It used to be we could resolve lots and lots and lots of cases informally once we got to the second level of appeal, and in some fashion that was, you know, more favorable to the provider. But CMS is getting much stingier with those settlements, and I think that's just a reflection of the agency's approach to enrollment these days. They're just very, very strict. Anyway, let's get back to the procedure here. It's a formal court procedure. Generally, it's a paper case where CMS will submit its brief, which is supported usually by all of the various evidence they have in their record to support their case. The provider then has the opportunity to respond and can submit a brief, their documentary evidence that should already be in the record, any new evidence they're going to argue good cause to submit, and then they have to submit the testimony of any witnesses via affidavit, and those all have to be submitted together. You can then request in your brief at an evidentiary hearing if there are any witnesses that you want to testify, or if there are any witnesses for CMS that you want to cross-examine. and the judge can decide whether he's going to permit that hearing. They're actually fairly uncommon. Most cases are decided based on the written record if they actually go to a decision. The procedural rules at this level tell the judges that they'd like cases resolved in 180 days. I will say that's the schedule they lay out when they send you their standard scheduling order for when certain documents are due. But if your case goes to a hearing, it's going to take way, way, way longer than 180 days. I had a case not that long ago that we decided we wanted to take to a hearing. We filed our brief, CMS had already filed it. And when the judge granted us a hearing and said, okay, here are your options, they were 18 to 24 months later before we could actually have that hearing. So if your case doesn't get informally resolved through settlement discussions and you move into sort of the briefing and argument stage of the case at the Departmental Appeals Board, and you actually go to a hearing, it could take 2 to 3 years to resolve your case. So these timelines are often completely unreasonable for providers, and they can't exist. They can't survive that kind of timeline. If you lose a civil remedies division, there is the opportunity for another level of review within the Departmental Appeals Board called the appellate division. Those cases are considered by 3-judge panels, and generally appellate rules apply to those cases. So you're arguing about errors of law, meaning you think the judge made an error in interpreting or applying the law, or what we call the substantial evidence rule, where we argue CMS didn't have substantial evidence to support its case. Really, really hard to win those cases. After that, if you're still not successful and you're still hanging on somehow to fund an appeal, you can go to federal court. Again, it's to the district court where you're located, and appellate rules apply, and you have to go through all the previous steps first before you can litigate anything in federal court. So let's go to the next slide. So apologies for going a little bit over, but thank you for those of you who hung on. Ashley and I are very grateful for your attention, and we're happy to answer a couple questions if there are any.
Hey, Jennifer, it looks like we don't have any questions.
Okay. So you've got our contact information there. If there's anything you'd like to discuss or you have questions after this, feel free to reach out to Ashley or me, and we will do our best to get back to you. Email is probably the best way to reach us, but you're welcome to use the phone number on the slide and reach out to us that way as well.
Cool. So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Ashley and Jennifer. Everyone from today's webinar will receive copies of the presentation slides via email, and I'll send those out tomorrow. If you have any further questions about today's discussions or another healthcare law issues, like Jennifer said, just please feel free to reach out to us at Loudspark. So have a good Wednesday and take care.